WPC number 3813 2020 regarding a cancellation of
out of district.
okay.
Last working day में क्या ही mention कर रहे
नेक्स्ट जनवरी मंथ में जनवरी में रख दिया
अभी जनवरी का बेंच पता फिर हमको नहीं
For judgment item 1 table 260 of 2016 along with item 2.
the divisions are dismissed. Sorry.
Dismissed on that.
For orders item 3 contents will 274 of 2024.
Perhaps this matter has been wrongly listed.
Contempt civil 274 of 2020. It has been reported by the office that late date fixed by the order dated 6th of December 24, that is 16 to 2025 is assigned. Considering the office will post this case on 21st.
Date for release.
कल मैटर था कल ये वाला मैटर डीपी में था
I'm sorry, I'm not aware of it, my lords.
इसमें मैंने देखी है एक सौ सात
It was not listed yesterday. It was not on board
But
yesterday.
on the last date, it was submitted that it was on 19th.
From DDS item 24 contempt civil 1004 of 2023.
I am pressed for time to file my reply to the so cause. Due to my personal reasons, I was not in a position to file my reply.
What is the nature of comment?
They were directed to hear me and pass a reasoned order in respect of the grant of second SCP.
They
Earlier,
have passed a reason order?
that he has not.
They have
did-
annexed it along with the copies.
Hello?
They have annexed it along
Yes,
with the
that I have also
Just
annexed.
have a look at it. इसलिए reply क्या फाइल करना है? If you are agreed by the reason order, you will have the right.
Kindly just
नहीं,
one
इस तरह
opportunity.
से नहीं होता है. Content में there was a direction to pass a reason order.
Kindly,
I passed a reason
kindly come to the next para. चूंकि निदेशक उद्यान झारखंड राज्य स्वतंत्र रूप में पूर्व से कार्य कर रहे हैं, उन्हें परामर्श दिया जाता है कि श्री प्रसाद का एसीपी वेतनमान के संबंध में वित्त विभाग झारखंड राज्य द्वारा निर्धारित प्रावधान के आलोक में अग्रतर कार्रवाई किया जाए. This authority was not directed. The Honorable Court has directed the OP number 2, the Director of Agriculture, whereas he has remitted the matter to the Director of Horticulture, who was not directed by this Honorable Court. Just a formal reply. My Lord will pass the order and the Honorable Court pleases.
See, that is only a follow-up. You just see, आता है वित्त विभाग झारखंड राज्य का संकल्प इतना के आलोक में श्री प्रसाद का दावा वेतनमान इतना को अमान्य पाते हुए अस्वीकृत किया जाता है.
Just time for just in the opening week. Just in the
कुछ भी नहीं है इसमें. They have passed a reason order. They have considered everything, whatever it is. It is for the follow-up orders. It is definitely.
they have stated so many erroneous facts in their order.
Therefore, you will have to pass a fresh, file a fresh. Contempt is 1004 of 2023. The counsel for the petitioner is present. Nobody appears on behalf of the opposite parties. The order dated 29/2022, passed in case number 4840 of 2011, reveals that
Para 7 is the operative part.
that's it. Reveals that the petition was disposed of, asking the respondent number 2 to dispose of the representation by a reason order.
I was also not personally heard by the said authority. He had instructed his subordinate that I have stated in a contempt petition.
Who was the authority?
Director of Agriculture.
Where
Jharkhand.
have you stated, sir?
Para 7.
Para it's 15 minutes.
Para 7.
Not properly heard. Right? Para 15. You have
But the
stated not
proper-
properly heard. Properly
Rather
heard, not
rather he instructed his subordinate to consider the claims of the petitioner and to submit a report with respect thereto. That I have stated in para 7. He was not personally heard. Thereafter he went
the
several
counsel
times.
for the petitioner has submitted that the respondent number 2 of the respondent / opposite party number 2 had instructed his junior to grant him hearing and did not hear him while passing the reason order. However, from perusal of paragraph 15 of the contempt application, it has been stated by the petitioner that the respondent opposite party number 2 has himself neither properly heard the petitioner nor he has properly himself considered the claim of the petitioner in accordance with the considering the requisite errors and the fact that reason order has been passed, this court is not inclined to proceed with further administrative case, which is hereby provided. It will be open to the petitioner to take appropriate steps in connection with the reason order if so advised. All contentions are left open.
Item 26, contempt bill 749 of 2024.
लॉर्डशिप इसमें सो कॉज रिप्लाई तैयार है वो फाइल कर दो
पढ़िए ना फाइल तैयार है तो फाइल करिए There is it. तैयार है ना फाइल करिए
फाइल कर दो
पैसा गया कि नहीं गया
I think कुछ पेंशन का कुछ डॉक्यूमेंट मांगा गया था वो नहीं आया है इसलिए वो वाला नहीं बाकी पैसे चले गए
वो तो पुरानी कहानी है as per the last order you are only to debit the amount where is it
पेंशन के अलावा सारे पैसे चले गए
पेंशन नहीं चाहिए क्या
पेंशन भी चाहिए उसके लिए डॉक्यूमेंट मांगे हैं तो डॉक्यूमेंट अभी प्रोवाइड नहीं किया
are
है
you there yes what is the position
Not 75% of areas of pension has been given, 25% has been withheld.
there could be some reason for it
No reason.
no reason
No reason
Some
assigned.
department will proceed.
Not in a similar matter before.
Similar matter content में नहीं चलता आप हमको बताइए 25% क्या बोल के दिया
No, nothing. Nothing mentioned. No reason has been assigned as to why my 25% of the pension has been withheld. Rest, my lord, payment has been made, my lord, I admit. The areas of salary given, leave encashment given, my lord, 75% of areas of pension have been given, 25% not given. As is evident.
75 just a moment 75% arrears of pension given current pension is full pension
No.
current pension is also 75%
Current pension, my lord,
but
for
pension fix हुआ होगा ना आपका
नहीं अभी हम लोग पेंशन पे करने को अभी भरे हैं But we
अभी
have
आप पेंशन
submitted.
पेपर भरे हैं
हाँ.
तो बाकी प्रोसेस कंप्लीट कर देंगे तो इस कंटेंट में अब क्या ही होने वाला
But if
I will just observe that
yes,
ठीक है
yes.
content case civil number 749 of 24 The learned counsel for the parties are present. Counsel for the petitioner on instructions has submitted that the dues to the petitioner has been paid. But so far as pension is concerned, only 75% has been paid, and the petitioner has been asked to fill up certain documents,
Which I have filled.
which he has already filled. आपका लिखते थे needful will be done shortly.
The
The
time
learned
frame.
counsel for the opposite party has submitted that if the aforesaid, but he has also received instruction that substantial amount has been paid to the petitioner. If the documents have been duly filled by the petitioner, the needful will be shortly done.
Not any time
Considering
frame.
the aforesaid circumstances, this court is not inclined to proceed any further in this particular proceedings, which is hereby drawn. If the grievance of the petitioner is not redressed within one month, 2 months,
2 months.
within 2 months from today, it will be open to the petitioner to file application.
Suffice.
That should be sufficient.
Suffice.
कर दीजिए, दोबारा कंटेंट पे नहीं आना.
करवा दो।
This petition is accordingly dismissed. 3 months कर दें, कुछ प्रोसेस है, कुछ सारी चीजें, ठीक है? 3
3
months.
months.
Lords.
All right.
You be in touch with them. There is no reason that they will not do the email.
Item 27, contemptible 814 of 2024.
Order complaint. Content civil 814 of 2024. Counsel for the party jointly submitted that the order dated 14/3/24 as in WCS number 6683 of 2023 have been complied. So belatedly, कुछ तो लेट हुआ होगा. Don't delay. Considering the approaches and this court is not inclined to proceed any further in this consent case. This proceeding is
Item 28, contemptible 922 of 2024.
Yes, beloved, yes, today I have filed this so-called beloved, in the evening.
repeat that grievance.
Regarding the compensation, payment of compensation, the acquisition of my land beloved, by the NHI beloved. And they have been directed to consider my representation, which they have not.
Considered
And
and
now,
passed a recent order.
yesterday they have filed the so-called reply, my lord, wherein they have annexed the copy of orders, my lord, which has been initiated. The proceeding has been initiated after filing of the counter, my lord, and after passing of the my lord order regarding the filing of the so-called. They have and in the that order, my lord, it is been
They
said
have passed an order, my lords, my ladyship,
कि-
if they are agreed.
just a minute. Page 30, my lord. This is order dated
कहाँ है आपका शोकस?
My ladyship, Shoko filed yesterday.
yesterday they have filed.
शोकन मंगाई. The cost of the meeting. Supplementary affidavit.
This is the copy, my lord.
Copy.
देखिए जब फाइलिंग हुआ है. फाइलिंग है.
Page 30, my lord. This is order dated 13/12/2024, my lord. Last paragraph. अतः NHI के पॉलिसी सर्कुलर सचिन सच के आलोक में आवेदक द्वारा वर्णित भूमि पर अवस्थित संरचना हेतु मुआवजा की मांग स्वीकृत की जाती है तथा भूमि की मुआवजा अस्वीकृत की जाती है.
So
This is the order.
maybe that the land does not belong to you.
Yes, that is
Thereabout
their
that.
stand, my lord. That is their stand. Yes,
The
I may be given liberty to challenge.
content civil 922 of 2024. Counsel for the parties are present. The learned counsel for the opposite party submits that show cause has been filed yesterday, stating that order dated 14/23 passing WPC number 791 of 2016 has been bypassed by reason. And part of the claim of the petitioner has been agreed. Considering the nature of order passed in WPC number number 791 of 2016. The recent order having been passed, this court will not incline to proceed any further in this contempt proceedings. Accordingly, the contempt proceedings are now. If the petitioner has any surviving grievance, he is at liberty to take steps as per the law.
Oblige, Your Lordship.
Item 29, contemptible 924 of 2024.
Yes, petitioner.
Comply, Your Lordship.
Comply.
Yes, ऑर्डर कंप्लाई हो गया लेकिन
So cause has been
पुनर्नियुक्ति शब्द यूज हुआ है माय लॉर्ड.
Matlab you have some grievance.
Yes.
Contempt civil 924 of
Madam, we have not filed yet, this is
Filed.
ready.
also for the petition. Parties are present.
Last page we'll see.
Our chauffeurs have been filed in the present case. During the court proceedings, taken on record. The learned counsel for the petition, the opposite party has submitted that order has been complied. The learned counsel for the petitioner submits that the grievance of the petitioner has not been fully redressed. Considering the nature of order passed in WPS number 3372 of 2023, this court
The last paragraph may be seen, Madam. श्रीमती कुमारी के अंदर दिया जाता है कि आदेश निर्गत तिथि से 1 सप्ताह के अंदर प्रकाशित विद्यालय में योगदान करना सुनिश्चित करेंगे.
पुनर्नियुक्ति के फल.
Yes,
जब order of termination or order of discontinuation have been set aside, ये fresh appointment कैसे होगा? Counsel for the petition has submitted that the opposite party has passed an order of fresh appointment, although as per the order passed by this court, the termination of the
Regarding
services of
this
the
matter,
petitioner on ground of overage was set aside. He submits that the order passed by this court has not been complied in the letter. At this counsel for the opposite party, this for time to file a fresh divorce. It will be open to the opposite party to take appropriate steps to ensure that the order passed by this court is complied with the letter. On the face of the order passed by this court, there is no question of fresh appointment.
माय लॉर्ड फ्रेश अपॉइंटमेंट नहीं है, पुनर्नियुक्ति, रीअपॉइंटमेंट.
Reappointment. ठीक है? Reinstatement.
reinstatement. Might be typographical
आप
error.
कर दीजिए उसको, शोकॉज में आप कर दीजिए, कंटिन्यूटी ऑफ सर्विस उनका हार्म नहीं होगा, ये सारा कुछ कर देंगे तो हम ड्रॉप कर देंगे, फिर करना ही है. Who will do it?
This is the letter of
Who has passed the order?
DSC Devgar.
Deputy Commissioner.
ठीक है?
It's DSC. Letters of DSC.
Continuation जब set aside हो गया, so he is entitled to everything.
I will check this. Okay.
First week February में रखना, Friday first week. ये था supplementary. 7th February.
Item 31.
Explaining the position, वो जो लिखे हैं ना, वो रहेगा. You may have to pass some fresh order, some rectification order, सब कर दीजिए.
Item 31. CRMP 3366 of 2024.
Yes.
For restoration of criminal division number 342 of 2021, which was dismissed by order dated 12th April 2024 on account of non-submission of surrender certificate due edition.
Have you started?
Lordship, it is submitted at the matter between the petitioner and the opposite party number 2 has been compromised.
नहीं चलेगा. Surrender कर दीजिए. ये तो हम restore नहीं करेंगे.
We will file it due edition.
You file surrender certificate. उसके बाद ही restore करेंगे.
Lordship, the
Surrender certificate लेके आइए, restore करेंगे, आपका तीसरा दिन केस नहीं. ऐसा नहीं हो सकता. 21 का केस को डिफेक्टिव छोड़ और सरेंडर सर्टिफिकेट मत चाहिए, उसके बाद बोलिए कि कॉम्प्रोमाइज
I'll procure the surrender certificate, so I'll file it by filing supplementary affidavit.
CRMP number 3366 of 2022. Also for the petitioner seeks interment. बताइए कब
4 weeks.
7th of February.
Yes.
Post on 7th of February. उपाय बता दें, जाइए सरेंडर सर्टिफिकेट फाइल करिए, लेके आइए, हम उसी दिन उसको रेस्टोर भी कर देंगे और आपका रिविजन रेस्टोर हो जाएगा, मंडे को मेंशन कर देंगे। और अगर मेरे पास रिविजन रहा तो हम तो मंडे को 100%
Organize it.
Item 32, CRMP 3372 of 2024.
This is the restoration of criminal revision number 110 of 2022, which has been dismissed for recall on 17th.
Surrender कर दिए?
Lord, the today's development is Lord, the today itself he has been arrested.
वेरी गुड। अब क्या करें? आप लाइए एलएस मेमो लाइए, वकालतनामा लेके
Milord,
आइए जेल
Milord.
से।
After it may be listed after vacation, Lord, first week, Lord. In the meantime,
3 तारीख
हाँ, नहीं 3 तारीख को नहीं, क्योंकि फाइल भी तो करना होगा।
नहीं 2 तारीख को फाइल करिए,
और
बंदा
हाँ,
जेल
3
में है।
तारीख, yes, yes. हाँ,
भैया,
हाँ,
थोड़ा
ठीक।
सोचिए।
हाँ, yes,
अगर जेल से
नहीं, नहीं।
वकालतनामा आ जाता कल भी फाइल करें।
ठीक।
CRMP number 3372 of 24. इसमें वकालतनामा फाइल होगा कि क्या फाइल?
वकालतनामा फाइल उसमें तो जेल का मुहर है।
Consequent the petitioner submits that the petition has been arrested. He submits that he shall file wakalatnama after obtaining fresh wakalatnama after obtaining it from the jail. Let this matter be posted on Twitter. Supplementary purpose.
Yes.
और बाकी सब removal of defective
नहीं, defective
और कोई
नहीं।
defect
डिफेक्ट नहीं।
Item 33, CRMP 3381 of 2024.
Yes, Lord. This is a criminal revision has been dismissed due to non-compliance of the preemptive order. Only type copy was required to be filed. That was also filed, Lord. But
क्या
due to
matter है? Revision में क्या matter?
revision is regarding the challenging order passed by the learned court below, Lord, whereby the section 311 application filed by the opposite party, here in this case, Lord, has been allowed. My 311 application was dismissed. On the ground,
What is the state of the case?
stage is that the charge has been framed, Lord, and thereafter, Lord.
311 की बात कर रहे
Yes,
हैं,
Lord.
charges।
Yes.
क्या stage है?
I mean, start नहीं हुआ evidence.
Small है, आपको तो कोई मतलब ही नहीं है, वोट ही नहीं proceed करता आपके बिना।
So that is the main case.
तो क्या करें? Restore करें?
My lord.
नहीं?
Yes, Lordship. As your Lordship may please.
CRMP number 3381 of Counsel for the parties are present. This petition has been filed for restoration of criminal division number 78 of 24, which stood dismissed on account of non-removal of effects in terms of order dated 3/7. The learned counsel for the petitioner submits that on account of inadvertence that affects the party. Counsel for the opposite party has no serious objection to the fair notice. Considering the requested submissions, the time for removal of the weight granted to the petitioner by order dated 3rd of July 24 in criminal revision number 78 of 2024 is extended till the time
2 weeks after winter vacation.
is extended till next year. Seventeenth of January.
Fahad alarm for the state, Your Lordship.
Upon removal of defects within the extended time. If the defects are removed within the extended time, office is directed to place the
From the list for orders item 1, WPC 5138 of 2008.
CIP disclosed. बताइए, ये क्या है? Petitioner absent.
इसमें लास्ट ओकेजन में नोटिस हुआ था, अभी सर्विस रिपोर्ट नहीं आया इसलिए।
इसका नोटिस का कोई काम ही नहीं है ना, वो आगे disclose. जब एडवोकेट ऑन रिकॉर्ड है तो किसी को कुछ नोटिस करने का जरूरत नहीं। आप बताइए क्या बोलना है?
My lord, I have no
No
instruction.
instructions?
No. But apparently they have departments.
WPC number 5138 of 2008. The matter was taken up, counsel for the parties are present. The matter was taken up on 11/24. On this day, Mr. Manish Mishra, the learned counsel for the petitioner, had submitted that he shall seek instructions in the matter. Today, when the case is taken up, he submits that he has no instructions. On the considering the aforesaid submissions, this petition is dismissed. Entry order नहीं होगा, नहीं entry हो गया होगा। PF वाला को रुकता है।
रुकना भी नहीं चाहिए उधर on the state.
लगता है this form जो है ना, bind up हो गया है। As I remember in one another case.
Well.
Well,
Well.
dismiss for non-prosecution करते हैं।
Not.
हाँ, dismiss for non. And you please.
Well.
Item 2, Criminal Region 1150 of 2019.
Your Lordship has been pleased to cancel the provisional bail of the petitioner by the order dated 11/9/2024, my lord, on the ground that the money has not been deposited. Now, my lord, I have inquired from my client. My lord, it has come, my lord, that the amount was deposited in the registry filing counter. My lord, may kindly have a look to page 12 of my petition. This IA, my lord. Page 12. There was direction to deposit 50,000. That was deposited, my lord, and acknowledgement has been issued by the
Page 12.
page 12 annexure of IA. Perhaps sorry. लास्ट में वो जो सिग्नेचर के ऊपर 50,000 इट वाज डिपॉजिटेड ऑन my lord नहीं कोर्ट फीस के हेड पे जाता है इट वाज डायरेक्टेड एंड डिपॉजिटेड इन दिस केस 50,000 किस हेड में जाएगा वो तो लिखते हैं कोर्ट फीस ही
नहीं इस तरह से तो नहीं ना क्या इस तरह क्या होगा डिपॉजिट कौन से ऑर्डर से 50,000
ये पेज में लगाए हो जो
पेज
पेज 30
पेज 7/11 ऑर्डर डेटेड 7/11/23 पढ़ी इस ऑर्डर के अनुसार ना जमा होगा
नहीं ड्राफ्ट ही फाइल हुआ था जमा हो जो इसको ये ड्राफ्ट ही हुआ था बट वहाँ पर लिखाया है कोर्ट फीस नहीं ऑर्डर में आया जो मलोड में
ड्राफ्ट जमा किए थे तो ड्राफ्ट का फोटोकॉपी लगाइए तब हम यहाँ से रजिस्ट्री से बोलेंगे वेरिफिकेशन
my lord, now he is in custody. My lord, if my lord may insist, my lord, I will.
custody
Yes, my lord. Your
कहाँ
lord.
है वकालतनामा?
लास्ट पेज में है रेटिंग का ऑर्डर ही ड्रॉ हुआ है पेज 16 my lord. My lord, this may kindly be seen my lord for the purpose of bona fide on the part of the petitioner, my lord. The certificate has been issued by the bank. Next page is the my lord the beneficiary list. Now, your lordship has, since your lordship has cancelled the provisional bail granted to the petitioner, so petitioner has been taken into custody, my lord, on 23/10/2024.
बहस करनी क्या? बहस करी finally?
Finally, my lord, the entire amount has been deposited. Now
Entire amount से क्या होता है?
now the
compromise हो गया है?
कंप्रोमाइज करने के लिए बोल रहे थे कि पैसा दे देंगे, हम लोग बोले पैसा दे देंगे,
पैसा जमा कर दिया
उससे क्या?
जो
Entire amount
compensation
means compensation amount.
हाँ compensation
कहाँ है बताइए? The entire amount has been paid.
compensation my
आप
lord.
बहस करिए finally.
ठीक है ये my lord में see the page 36 of my brief main petition. The original amount was 42,000. With compensation, it was directed to be deposited by the petitioner 50,000. Now it has been deposited. Now the recent judgment has, which my lord, of course, I have could not brought on today itself. My lord, the Supreme Court in the latest judgment, I'm just placing. In Raj Reddy Kalem versus State of Haryana and others, my lord, it has been held that if entire compensation amount has been deposited, then my lord, there is no case. Even if the complainant is disputing. नहीं हुजूर, हम तो आज आईए पे आए थे, इसलिए हम नहीं लाए थे. आईए पे आए थे, कस्टडी में है.
कस्टडी में है तो अब तो सारा प्रोविजन पे का कहानी खत्म हो गया.
नहीं तो इसको केवल रिस्टोर के लिए हम प्रे कर रहे थे और इसको रख दीजिए हुजूर.
रिस्टोर डीएफडी थोड़ी किए हैं.
नहीं रिस्टोर डीएफडी ओरिजिनल स्टोर का ऑर्डर का रिस्टोरेशन. मतलब टेबल सेंस योर लॉर्डशिप
जब वो अंदर जेल में है, आप बहस करने को तैयार नहीं.
नहीं तैयार है हुजूर, हम तैयार हैं. आज केवल हमें इसको चूंकि हम आईए पे आए थे.
आज के बाद तो ओपनिंग पर ही कल होगा ना.
इसमें हुजूर जो ऑर्डर की थी उसको देख लिया जाएगा. हुजूर ने ऑर्डर किया था कि 50,000 सिंस इट हैज कम पर हुजूर ऑर्डर है हुजूर का ऑर्डर है कि 50,000 नहीं जमा हुआ है.
क्यों ही रिकॉल करना है? हम तो बोल रहे हैं आप फाइनली बहस कर लीजिए. हो सकता है आपको ऐसे ही खत्म हो जाए, सेटिस्फाइड हो जाए ऑर्डर. आप बोलते पैसा जमा करने पर आपका कस्टडी खत्म, मतलब देयर इज नो नीड फॉर एनी इम्प्रिजनमेंट अंडर एनआईए.
since compensation has been paid. हाँ जजमेंट हुजूर
थोड़ा सा आपको डाउटफुल लग रहा है कि ऐसा लॉ होगा.
नहीं आप देख लीजिए, एक बार देख लीजिए, हो सकता है. हम तो हुजूर नोट करते हैं, उसी को नोट कीजिए. राज रेड कलीम डिटेल तो इसका केवल नाम का ही है एंड वर्सेस स्टेट ऑफ
Admission item 3, WPC 4502 of 2006.
After the I was directed to file an affidavit showing compliance of order dated 30th of June 22. We have filed an affidavit, madam, and the order has been complied with. Yes, madam. हमने डॉक्यूमेंट लौटा भी दिया है, फाइल एफिडेविट टू दैट.
WPC number 4502 of 2006. Nobody appears on behalf of the petitioner. The learned counsel for the respondent has referred to order dated 36/2022 and 28/11/2022. He has submitted that the original requisition has expired long back, and even Rajkumari Prabha
No, वहाँ थोड़ा correction. Last date I had submitted probably she has also read. She was alive on the date the document was handed over to her.
He has submitted that an affidavit dated. कब आप affidavit बना?
हमने affidavit दिया तो, and 9th of December.
कहाँ है यार?
Copy.
क्या ही ऑफिस करता है? Handy है लोग. Who is this? कहाँ है? Who is this person responsible? 9 December को affidavit फाइल हुआ है, यहाँ पे रिकॉर्ड करनी है. चेक करिए. लोग extensive training चाहिए. जुलाई में कौन है आरटीआर? Who is responsible for this? File हुआ इसमें सब?
Yes, yes, I handed over. The last page of lordship is seen. Receiving is there.
The legal counsel for the respondent has submitted that an affidavit dated 9/12/24 has been filed with the district. And the documents have been handed over to the wife of the petitioner, Mrs. Raj Kumari Prabha. She has acknowledged the fact that she has been handed over the original sale number 7632 by the officers of the LCB dispute. However, it is not in dispute that the original declaration has expired. Considering the supplementary contract filed on behalf of respondent to study within 9/24. No further order may be passed in this case. Therefore, खाली यही tag है ना?
Yes.
Same. Sale deed का number भी दूसरा है.
Sale deed for plot number the same.
Sorry.
Sale deed for plot number in the rate application they have given the plot number. We have given the sale deed number.
अच्छा plot.
Yes, ma'am.
कोई substitution filing बना.
No, but from the order to 22, it is apparent that he had died and yes, ma'am. Pursuant to the order, it has been informed that petitioner Radharaman died on 25th of November 17.
That's right. That's it. This petition is about. Yeah. Record fill.
Item 4 WPL 5900 of 2006.
In this case, they should directed to verify that condonation, any petition for condonation. They should 4 points. First is that the club only members and retired members, they are the members who can join the club, so it is not for the trade business. Second, condonation, any petition for condonation that is the prescribed period 90 days, that has not been filed. and no discussion about that. Third is that about service of notice ex parte passed, but there is no finding regarding that service of notice was done and it has been received. So third point and fourth is on leadership. I verified and I have come to know that he is working after his removal. He is working in other company and now at present for several years he is working in Sudesco Private Limited.
रजिस्ट्री को नहीं बोलते हैं ऑफिस ऑर्डर इशू कर दीजिए कि हमारे पास इस तरह से ना टूटा हुआ टैग पुराना रिकॉर्ड है ना टैग खींचते देखिए ये सिस्टम के हाथ में आ जाता है घर पे भी आ जाता है घर पे तो हम खुद ही टैग कर देते हैं यहाँ तो कटवा और टैग भी नहीं है ऑफिस ऑर्डर इशू करके कम्युनिकेट कर दीजिए आज मेरे पास कोई भी रिकॉर्ड इस तरह से प्रॉपर्ली टैग नहीं होगा तो आई विल जस्ट इशू शो कॉस्ट पुराने रिकॉर्ड्स हैंडल करना बहुत मुश्किल है There is a response for the last date they were creating.
President is working in Sudexo India Services Private Limited. So leadership will permit me, I can bring this all this on record because just recently I have come to know that he is working.
Record आया?
Record नहीं आया.
Also for the nobody appears on behalf of the respondents. When it comes to the petition service that there are certain facts which she wants to bring on record, particularly the employment of the private respondents.
Private, no, yes, private respondents.
Only one respondent.
One respondent.
With regard to employment of respondents. Pose this case on 7th of February. The
7th. इसके नेक्स्ट वीक कर दीजिए बेटी की शादी है इस वीक में
7th की बात है 7th की बात Pose this case on
Item 5, WPC 5934 of 2007.
Lordship में कहने से ऑर्डर देते 3/10/2024
ऑर्डर्स
नहीं ऑर्डर्स डेटेड
अभी ये किस हेडिंग में ऑर्डर्स में
नहीं एडमिशन में
आप क्या बोलते हैं
उसमें एक काउंटर फाइल की है सप्लीमेंट्री एफिडेविट फाइल की इंक्वायरी की है डिप्टी कमिश्नर उसमें बोल रहे हैं गैर मौजूदा जमीन है हम पोजीशन में नहीं है
ये 6 अशोक सिंह
हाँ
6 है
6 सॉरी आई एम सॉरी
Item 5 है.
Item number 583
5934.
I am sorry.
WPC 5934 2007.
Who is the preemptor? Petitioner is the preemptor or the opposite?
Well, it's petitioner.
देख के बोल रहे हैं कैसे बोल petitioner is the preemptor and he is not interested in the case, तो case को dismiss ही कर देना है. But if the petitioner is the purchaser of the property through registered sale,
Petitioner is the preemptor.
कहाँ से बोला है? Petitioner कौन?
Page 40 matters, in which matters the order of the matters board of revenue matters, in which there is a contention that matters the law that the partial preemption is not permissible settles since the petitioner has not been able to establish that none of the vendee respondents are prior to land adjoining the disputed land, and that the disputed land is agriculture in nature. The claim of the petitioner must be.
Partial preemption नहीं हुई. आप कौन है respondent? Yes. Who are you? आप किसकी तरफ से हैं? Original owner, purchaser, कौन?
Even it is recorded.
बताइए, आपको ये भी नहीं पता है आप कौन?
Even it has come as in the Khatiyan that the entry.
Property in the connection with the plot number 7.
एक सेकंड. आप प्राइवेट रेस्पोंडेंट है ना?
Private.
और प्रीएम्पशन का केस है. आपसे सिर्फ एक सवाल पूछ रहे हैं, आप कौन हैं? You are the purchaser, you are the preemptor, or you are the original owner of the land. ये restored कब हुआ है? This case was dismissed for default, right? CUP number 318 लिखो तो कब discuss होगा? 300. ये अलग से लिस्टेड नहीं है. दो रिस्पोंडेंट इसमें ऑलरेडी डेड हो चुके हैं. इसमें कोई डिलीट नहीं हो सकता. इसीलिए वो आ नहीं रहे. WTC नंबर 4934 of he appears on behalf of the petitioner. Also for the state and the respondent are present. Also for the state submits that this petition has been filed by the following. The learned counsel for the state and the private respondent submits that the petitioner is a preemptor. And as per the issued order, partial preemption is not permissible.
Even the land is not an agricultural land. That
He has also submitted that the land concerned is not an agricultural land.
in the Khatian it has been recorded as Ghar Angan Malaj.
In Khatian, it has been recorded as Gharbani.
Ghar Angan.
Ghar Angan. The since the petitioner is absent, this petition is dismissed for non-posture. पोजीशन में नहीं होता उसके राइट भी डायग्राम कोई याद नहीं लग रहा
Item 6, WPC 583 of 2013.
In this case, as per the order of this Honorable Court, the Deputy Commissioner has filed a supplementary counter affidavit with regards to the inquiry matters, how the name of the petitioner has entered into the revenue record. The reply has been filed in paragraph 7 of the supplementary counter affidavit matters. That means the revenue officer who has entered the name of the petitioner in the revenue record has already been retired who has mutated the said land.
and you dispute the income.
Yes, Manoj.
Lots of time praying for not today responding number 5 because Argue Council Mr. Vishal Kumar is out of the station now.
हमारा भी तबीयत I am also praying for time lords. तबीयत आज ठीक है ज़्यादा खांसी है
समझ के रिपोर्ट में आपकी तबीयत खराब हो
नहीं तबीयत खराब है रियली तबीयत ठीक है अदरवाइज हम टाइम लेते हैं
counsel for the petitioner and private respondents on personal grounds. Counsel for the state is also present. Holds this case on 7th of February 25. In the meantime, if so advised, they will file a response to the supplementary affidavit filed by the Deputy Commissioner by affidavit dated 16/12/24. Affidavit dated 7/12.
Item 7, WPC 6945 of 2016.
This is for quashing of annexure 3, whereby the circle officer has directed me not to make construction on my righty land. But the short point is a title suit was filed by the petitioner herein against state. The suit was decreed, against which the state preferred title appeal. Title appeal was dismissed for non-prosecution. In the counter, they say that they have filed a restoration application. That restoration application for restoring title appeal has also been dismissed. Until date, no step have been taken.
Our counter establishes the same facts as the petitioner has stated, Your Lordship. The revocation case was dismissed. The revocation case was not allowed.
Who is the circle officer to say not to make construction? The cattle has, as on date, the cattle has been decided in their favor. Whatever be the remedies, we do not know. State is a party in the cattle. क्या है ये prayer की क्या है?
The prayer is to quash the notice.
Quash the notice, Lord, by which the circle officer directed us not to make construction.
Notice.
Yes.
The notice is that
Annexure 3, Lord. And Lord, at initial hearing only note this notice was kept in abeyance by order dated 19/7/2017. And I have taken instruction note since the order was kept in abeyance, construction has already been completed. So not if we only want at Lordship may pass an order that since state appeal have also been dismissed, revocation has been dismissed.
Description of property same?
हाँ same.
आपसे काउंटर में क्या लिखा है?
Counter में ही लिखा
Your
है.
Lordship, we've taken the stance that they have obtained the property based on forged hukumnama and everything. Then we have stated that the revocation case was to be filed after obtaining of certified copies. Thereafter, no instruction, Your Lordship. Counter was filed in 2017.
But so far as suit is concerned, they said the title appeal has been dismissed in para 10 of the counter, and revocation case number 49 of 17 has been filed for restoration.
Restoration के लिए revocation किस फाइल
लेबलिंग तो रेस्टोरेशन होती है लेकिन वहाँ पे revocation ही हुआ.
It has been taken up as a restoration only.
No, order sheet and not certified copy mention भी वही करता है revocation case.
Pages 13 and 14 of the counter.
हाँ, बट हमको लास्ट ऑर्डर हुआ था कि प्लेंट फाइल करिए टू शो कि हाँ व्हाट वाज द सूट प्रॉपर्टी दैट वी हैव डन. Yes. Annexure 1 plaint. Supplementary affidavit note dated 14/8/2023. Khata 64 note plot number 154 area 0.5. Sorry? Yes. But decree is annexed with the writ petition only, but annexure 1. See page 18. First page में नोट्स पार्टी पोजीशन में राजेंद्र प्रसाद सोनी प्लेंटिव.
ये जो आपका प्लेंट है
Yes,
उसके बाद क्या डॉक्यूमेंट कराना है?
प्लेंट के बाद
जजमेंट
जजमेंट है.
जजमेंट का फाइनल
Yes.
आदेश
और जजमेंट का पहले इश्यूज जो है पेज 19 पे इश्यूज है.
right at the interest position everything was declared.
Yes, yes, it was declared.
And the order cancelling the Jamabandi was also sent.
Yes.
Notice में area notice properties. है आपका प्रॉपर्टी डिस्ट्रीब्यूशन और नोटिस में 64 है
हाँ 64 है 154 एंड 0.05.
लेकिन जो प्रॉपर्टी डिस्क्रिप्शन है
Yes, madam. खाता नंबर 64/28, प्लॉट नंबर 154/2, एरिया ये.
64 का पार्ट है
तो 64 का पार्ट है क्योंकि हम तो
In the
प्लॉट इन द सूट.
एंड इन द नोटिस
नोटिस सेम नोट्स क्योंकि वो
प्लॉट नंबर 154
हाँ 154 है.
154 का पार्ट नहीं
सॉरी मैडम
154 का पार्ट नहीं है नोटिस
नहीं
154 about
पूरा
5
ही
decimals. 5
नोट्स
area of
खाता 64 प्लॉट नंबर 154 एरिया 0.05 का
That's
तो
right.
प्लॉट भी
हाँ ठीक है
हाँ
लेकिन आपका खाता नंबर इज 64/28 एज पर द प्लेन
यस
Plot number is 154/2.
Yes.
तो ये 154/2 तो part होगा ना?
But इसलिए तो हम बोल रहे हैं कि हम जो सूट में contest करके जीते, I am making construction on that portion only.
So
Yes.
so the provided you are making construction on this property.
Yes. That your lordship will clarify.
That I will
Yes,
clarify only
definitely.
to that extent.
Definitely.
The learned counsel for the parties are present. This petition has been filed for the following reasons. The learned counsel for the petition submits that.
May I have your lordship's leave notes? Not my junior.
Right title interest in possession with respect to the property involved in this case has already been decided in favor of the petitioner in civil suit being title suit number 26 of 1999. He has submitted that the appeal filed by the state against the judgment and decree passed in the title suit is to dismiss for dismiss for default and the restoration to the same have also been dismissed. He has also submitted that the plaint of the title suit has been brought on record by filing an affidavit dated 14/8/2020. The judgment is also on record. The judgment in the title suit is also on record. Upon being pointed out to the petitioner that the description of land as mentioned in the include notice as contained in Annexure 3 dated Two 10/2016 does not exactly match with that of the title suit. The learned counsel for the petition has submitted that the petitioner is only concerned with respect to the property which was involved in the title suit. And as per the case of the petitioner, he is in possession only with respect to the property which is involved in the title suit and no more. He has submitted that the circle officer can also measure the land if so required. The learned counsel for the respondent has submitted that it may be observed that the petitioner has title only in connection with the property which was involved in the title suit and no. Correct? After hearing the learned counsel for the parties, this court finds that the include notice gives the description of property as village Kasmar, khata number 64, plot number 154, area 0.05 district. And the description of property in the title suit is village Karmar, khana number 99, PS and Anchal Pratapur, district Chatra, khata number 64/28, plot number 154/2, area 0.05 decimal, boundary north Parthi and Banyan Tree, south Rasta, east hospital, west Sadak, within bracket, Pratapur - Kundar. This court finds that the suit has been decreed in favor of in which the state was party, and right title, interest and possession with respect to the suit property has been declared. An order of the Deputy Commissioner dated 11/2/2002 cancelling the Jamabandi has been declared to be non-effective. Thus, the petitioner claims the property which was mentioned in the application and no more. In view of this court finds that the property description in the notice does not exactly match with the description of the property mentioned in the title. In such circumstances, it will certainly be open to the respondents to take steps in connection with properties which were not subject matter of title, and this will require all responsibility. This petition is accordingly disposed of.
Criminal Item 8, Criminal Vision 1424 of 2018.
Yes, well, the petitioner has challenged the ex parte order passed on the proceeding under section 125. The petitioner is the husband and the opposing party is the wife. But the facts earlier the matters was being heard, the interim order has been passed, the certain conditions were there for making payments. The petitioner has been making payments, sometimes excess manner, sometimes less, because he is maintaining the education of the children, all those things were there. During the course of the argument, a situation arose when one of the honorable judge said that can there be any settlement? Well, the proposal came from the side of the wife, certain proposals came which were certain conditions were there. Most of the conditions were agreeable, but the condition of the petitioner is that she will have to come immediately in the matrimonial house. That reason in matter is not being settled. That's why now I have no alternative but to argue the matter on the merit. In this case, the marriage has taken place on 28th of January 2003. They have got the two children. Now they have also grown up. Well, I have also personally tried to get the matter settled when the matter was for negotiation. I don't know why it has not culminated. Both were agreed in my presence, but then from the month of November 2017, they are living separately. On 23rd of February 2018, the wife filed an application under section 125 at Dhanbad. The husband is residing at Patna, making claim of certain amount for maintenance.
What was the claim?
Pardon me, 30,000 for maintenance.
What does the husband do?
He is the engineer, the national engineering road construction department. On notice, the husband appeared, and on appearance soon, their conciliation was held at Dhanbad before filing so-called. on 14/6/2018. And then on 21/7/2018, so-called was filed by the husband. Then on 2 days thereafter, on 23/7/2018, evidence on behalf of the wife was laid, and her evidence was closed on the same day. Thereafter, some mistake took place. The petitioner's counsel heard it 25/8/2018 as the next date. Here, this is the, but actually it was 25/7/2018. I am clear to your lordship. And the petitioner's counsel who heard it 25/7, he communicated the fact that you have to come to make the evidence on 25/8/2018. Matter was listed on 25/7/2018. And that's why on that day, the petitioner failed to appear because he had the information about 25/8. So on 25/7, evidence on behalf of the petitioner was closed without having any evidence. Then matter was fixed for the next day for the argument, 26. 26/7, 25 को ही चूँकि petitioner को information हुआ अगस्त के लिए, मगर it was a July, 25/7 July. So 25/7 को evidence close हो गया, 26 को argument के लिए हो गया, and the 27 को order pass हो गया, and 30/7 को जज साहब रिटायर कर दिया. एक्स पार्टी ऑर्डर है, इसी के खिलाफ है. So we want that the order may kindly be set aside. He may be given an opportunity of being heard.
Let us see your show.
Page 26.
What is your show cause on the point of living separately? And what is your show cause on the point of quantum? Marriage is admitted, children are admitted.
Yes, marriage is admitted, children
वो
are
चीज़ बताइए, आपका सैलरी पर आपका कितना ऑब्जेक्शन है आपका सैलरी? आपने सैलरी बताया होगा ना सरकारी आदमी.
So-called में तो हम नहीं. Question is not of quantum. The question is that I must be given an opportunity of being heard to lead
Therefore,
evidence.
I am asking you. मान लीजिए कोई total family में 4 लोग, ठीक है, 4 persons in the family.
ठीक.
And if the entire amount of salary etc. stands admitted, उसमें क्या ही evidence है?
No, that's why, my lord. In fact, my lord, the petitioner was having at the time, ailing father, bedridden ailing father.
वही देखना चाहते हैं आप.
जी हाँ, ठीक है. From page 27 onward, paragraph 4E, it will be relevant to place, that the statement made in paragraph 4E of the petition are denied by answering respondent. Answering the respondent submits that in July 2015, respondent was transferred to Purandar, West Bengal. At that time, the respondent children were studying in the reputed school of Patna, and petitioner decided to stay at Patna for good education of her children. Respondent regularly visited Patna and regularly paid amount of school fees, household articles, but the petitioner always insulted regularly to the respondents by her cruel act. The petitioner from there came to Durga Puja vacation of his school to Dhanbad along with her children. He is saying about his wife, children, but in spite of the best repeated effort of the respondent to return back, she refused to come to Patna. In December 2015, respondent brought petitioner and the children to his working place, that is Kuch Bihar, West Bengal, stayed there. In the year 2017, the hip of respondent father was fractured, and due to the kidney failure, the doctor suggested to go to Delhi for better treatment, where the respondent was to stay for 5 months. In the said period, the respondent visited her wife at regular interval and paid all expenses. Respondent mother is also 75 years old, having many diseases, for which respondent engaged one male caretaker for the father and one female caretaker for the mother for monthly payment of 25,000 per month. The statement made in paragraph 4A petitioner are house and denied. The statement made in paragraph 4G of the plain.
That you had contested. Now you just come to paragraph 10. जो आप अभी ग्राउंड से बताएं दिखाएं हमको
जी
फिर आप पिटीशन से सब समझें पैरा नंबर 8
हाँ जी paragraph 8 that the respondent submits that the petitioner along with the respondent live together at
पैरा नंबर 8 of the petition
वो petition हम शोकॉज कब पढ़ रहे हैं
शोकॉज तो देख लिया आपका टेस्ट करके
जी जी
वैसा कुछ क्लियर की एडमिशन नहीं है लायबिलिटी को भी टेस्ट कर रहे हैं तो सर्विस
जी तो paragraph
नंबर 8
of petition application
actually you have made so many allegations
जी हाँ that on 23/7/2018 case was listed under the heading for evidence on behalf of the opposite party, which was closed on the same day after cross-examination, and 25/7 was fixed for petitioner's evidence, but he could not appear due to misunderstanding of date. On 23/7/2018, advocate of the petitioner was under impression that the next date is 25/8/2018 and accordingly informed the petitioner to appear on 25/8/2018. Lawyer certificate is also included. In addition to this, due to constrained work and distance of 800 kilometers from the posting place of the petitioner, 24 hours journey time, it was not possible to appear on 25/7/2018 on such a short notice. The petitioner and the opposite party both were absent and the evidence on behalf of the petitioner was closed. Next day was fixed as 26/7/2018 for argument. On 26/7/2018, the opposite party was present but the petitioner could not appear. The petitioner's counsel had not appeared on the date, that is on 25/7/2018 and 26/7/2018. Thereafter, on 26/7/2018, it was fixed for orders and final judgment was passed on 27/7/2018, wherein the petitioner and counsels were absent.
Yes, opposite party, what do you say? It has been done in a hall list.
Lords,
It has been done in a hall list.
Lords, may kindly have a look to the immune order. Lords, my learned senior friend, he started that the order is ex parte. It is not ex parte.
No, it cannot be said ex parte. He has been participating.
No.
He has been participating.
He has been participating. He has cross-examined the.
It is not ex parte, but his opportunity it has been used in the.
Now, my lords, two things has to be disputed. First is whether there is relationship of husband and wife. There is no dispute.
Children, no dispute.
Children, no dispute. My lords, the second is the quantum. The income, he has not disputed. And liabilities.
He's talking about some liabilities.
That is not in dispute. Now, my lords, as per the last pay certificate which has been filed, his income was 90,000 per month. His salary, he is executive engineer in road construction department in government of West Bengal. His last pay certificate was filed before the Honorable Court, my lords,
You see,
and it was 90,000. Now, my lords,
you see, he has got 2-3 reasons. First is there was no reasonable excuse to use it. That is also one of the conditions for grant of maintenance.
I could not.
Is there any criminal case pending between them?
No.
No. So therefore, this also is a part of maintenance. This is also required to be adduced before the court on behalf of the husband, whether there was any reasonable cause to leave separately. The wife, this is one of the conditions for grant of maintenance. What I propose is that this particular order, which has been passed in a couple of days, that can be set aside. Whatever be the maintenance that will be given by way of interim arrangement, you both of you file your assets and liabilities in terms of Rajesh versus Neha, and then you proceed.
Lords, on the last occasion, the proposal was made for settlement.
We don't bother about it.
My lords,
Proposal is all over.
just a moment. वो आइए दीजिए.
आप समझ नहीं रहे, आप क्या बोले पूरी तरह से ध्यान दें.
My lords, this is case of 2018.
आपको क्या
Now,
बोल रहे हैं? जो भी आपका maintenance fix हो, that will continue to be paid by way of interim arrangement. Right?
the entire amount.
The entire amount. आप बोलिए ना 1 महीना में decide करा दो, क्या ही दिक्कत है? ठीक है? That will be continued only as an interim maintenance.
My lords.
It will be subject to the final adjudication. Both the parties file your affidavit in terms of assets and liabilities as per Rajesh versus Neha, because that is the mandate of law, right? And after that, he has to give evidence. आपके कितने witness हैं? कितना evidence देना चाहते हैं?
Husband will be appearing on maximum 1 or 2 more.
1 or 2.
Maximum.
Both team date is more than sufficient for your evidence.
Only since he is in the service, he will have to take leave. Only that will be the only.
Lords,
कोई आपकी order की basis पे
during
आपको आराम से-
pendency of this revision, my lords, what has happened? He is paying only 50% of the maintenance. If your lords, it is falling from your lordships that he will pay the entire amount of maintenance as
I am
interim
not saying
maintenance.
as earlier, whatever has been fixed by this court, he will go on making that payment, and the case will be decided during assets and liabilities का affidavit आ जाएगा, तो अपने ही सारा दूध का दूध पानी का पानी हो जाएगा, फिर करना चाहिए.
But he is paying more than that for education of the children. 90,000 for admission, several lakhs for admission of their student, son and daughter.
He is paying for his son and daughter.
Certainly.
He is not.
कोई एहसान नहीं कर रहे हैं.
जी नहीं ठीक है, हम कहाँ कर उसको नहीं बोलते. But because it is his children.
बच्चे अब कितने बड़े हो गए?
Well, they have grown up.
They are grown up. One is of 11. The daughter is of 11 years, my lords, and the son is 17.
Fairly, not so, it can't be said so mature, but they are about to be mature.
Maturity तो maintenance के terms में तभी होता है जब बेटी कमाने लग जाए
जी नहीं.
और बेटा majority age में.
नहीं.
उसके पहले सब
नहीं, अभी they are both
are studying.
both are studying. One is studying somewhere in a very prominent school, Meladon. The only difficulty is the wife is not ready to go with the husband. And there are some forces behind it. They just want that the wife should remain at Dhanbad.
क्या ही आपका conduct है कि आपकी बीवी खाती है?
नहीं.
कुछ तो हुआ होगा ना दोनों के बीच में.
अब ये नहीं.
आप बोलते हैं assault, आप लिखे हैं कि मारती भी है. बहुत serious बात. बहुत serious बात.
Lords, on
The lady is assaulting you, husband. लेकिन नया कहानी है, आप ही ऊपर से
Just
का कोई केस किया है क्या?
beyond the record, one fact. The ailing father-in-law, ailing mother-in-law. And the lady was not ready to take care of them. And that's why she had run away.
Husband is also equally responsible for taking care of the patient.
Yes. Certainly.
Merely because he is an earning member, he cannot reside
Escape
from
the
his
there cannot be.
responsibility to take care of his parents, and he has kept somebody
Of
to take care.
course.
Some nurse या कुछ ऐसा दिख रहे हैं और so possible. यही कर सकते हैं.
On the last occasion,
जो हो
learned
गया
senior
पेमेंट
friend,
कर दिया सो कर दिया करंट पे कुछ लमसम हम लोग पेमेंट करा देते हैं 2-3 महीना यू हैव सम एक्सपेंसेस एंड देन 1 महीना में डिसाइड करा लीजिए एसेट्स एंड लायबिलिटी तो इनका तो सारा इनकम टैक्स पे आता होगा
हाँ यस, तो सारा कुछ आता है.
पर आप भी अपना रिटर्न फाइल कर दीजिए ऑर्डर करते हैं दैट इज द मैंडेट ऑफ
Milords, that is the mandate, Milords.
एंड देन यू कैन आल्सो पुट ऑन रिकॉर्ड कि बच्चों के ऊपर क्या खर्चा है ये तो सारा रिकॉर्डेड चीज है इसमें कौन सा ऐसा छुपाने वाली तो कोई चीज नहीं अब तो वहाँ पे तो रंजीत वर्सेस बिहार में ये भी बोला है कि अगर मान लीजिए कुछ एडिशनल ट्यूशन चाहिए या मान लीजिए कुछ एडिशनल वोकेशन करना चाहते हैं म्यूजिक या व्हाटएवर इसका भी एक्सपेंसेस बेयर करना
Primary question is this, well, so far 125, whether the wife is ready to reside with the husband or not. And if she is not willing to reside, then the question is whether she will be entitled for maintenance.
whether she is
That will be
reasonable excuse of not
Excuse.
deciding.
a reasonable excuse, yes.
Milords, only,
Reasonable excuse is a matter of opinion.
Milords, in all cases, Milords, the FIR cannot be lodged. Milords, all ladies cannot lodge the FIR against her
Or
husband.
males also cannot lodge their FIR against their wife.
Milords.
Vice versa.
Now, thing is, Milords, if we have not chosen to lodge FIR against the husband, it cannot be said that there was no torture and there was no
The
reasonable.
wife must have been
Milords.
cross-examined.
Yes,
तो
and they have not.
evidence दिया होगा अगर cross-examination
This
हुआ
finding is there in the
नहीं-
impugn order. This finding is there in the impugn order that there is no rebuttal with respect to Milord's torture and other things. That finding is there in the impugn order.
Fresh cross-examination कुछ नहीं होगा जो
नहीं होगा.
already material है
Yes.
उसके आगे ही हो सकता है fresh cross-examination और fresh 311 और ये सब कुछ आगे नहीं होगा.
वो कोर्ट अपना impugn order में लिखा है कि ये कहीं contradictions नहीं लिए, rebuttal नहीं लिए
कोई बात
with regard to torture and.
थोड़ा haste में तो हो गया
He has already filed his written statement in the case.
कोई further show cause का भी scope नहीं है ठीक है affidavit assets and liabilities आ ही जाएगा and assets and liabilities का जो affidavit आएगा that will cover the period involved the entire period कब केस फाइल हुआ
This was filed.
My lord, appointed document 18.
2018 से
23/2/2018.
बस उस समय से पूरा assets and liabilities का affidavit आएगा
ये present revision का.
नहीं वो जो डिमांड होगा उसमें पूरा ही आएगा ना
हाँ yes.
उसके बाद ही कोर्ट फिक्स करेगा पूरा एसेट्स एंड लायबिलिटी एफिडेविट विल कवर द एंटायर
But during the pendency of the application, Milords, in the meantime, he will. On Milords, if it is on a monthly basis, it would because if there is delay, we would be.
एक महीना एक महीना सब डिपेंड अब बोलिए सर आप क्या पेमेंट करते हैं कुछ आपको
My lord, 2 lakhs rupees, my lord, has been paid in pursuance of this honorable court's order.
That is the areas.
2 lakhs rupees on account of the areas and 15,000 for the wife and 15,000 for the children. यही ना?
15,000 for the wife आप पेमेंट किए
15,000 for
for the
No,
everyone
only 15,000. Only 15.
एक बार order interim order देखिए
Order number 7 may kindly be seen, Milords, dated 5/7/2019.
वही तो 30,000 he is making payment.
आप पेमेंट कर रहे थे वो आप कंटिन्यू कर रहे हैं क्या
हाँ that is still continue.
15,000 is being paid and apart from that arrears का आपने 2,000 रुपए
2 lakh. Part of areas, not the entire areas. Part of areas.
और आप बोलते हैं बहुत खर्चा करते हैं क्या खर्चा करते हैं कुछ और भी खर्चा करते हैं बच्चों पर
हाँ ये for their education admission में I'm just instructed to say more than lakhs of rupees has been spent in admission of the son. He is not studying in India. I'm sorry, not studying in Bihar or Jharkhand. He is somewhere in Maharashtra. Well, my learned friend probably.
For further education also.
Yes, yes. For quality education, not only the quality education.
पढ़े लिखे लोग हैं, पढ़ाई को तो वैल्यू करेंगे ही ना। Total division number 1428 of 2018. Appearance the delegates or the legal councils appearing on behalf of the parties. This petition has been filed against the order dated 27/7/2018, passed in original maintenance case number 87 of 2018 by the Principal Judge Family Court Dhanbad, whereby application filed by the opposite party under section 125 of CRPC has been allowed and the petition has been directed to pay rupees 15,000 per month to the wife and rupees 7,500 to each minor children, payable by 10th of each succeeding month. The order has been passed to pay the maintenance from the date of application. The Learned Council has submitted that the proceeding is going to be ex parte in as much as the petitioner had appeared before the court and ultimately filed his show cause on 21/7/2018, contesting the claim, and on 23/7/2018, the evidence of the wife was closed, and on account of some confusion, his counsel had informed him that the next date was 25/8/2018, although the next date fixed was 25/7/2018. The Learned Council submits that the petitioner is in government service, an engineer, and it was not possible for him to attend the court proceedings on 25/7/2018, although he was informed by the council later on about the date. However, on just one day, that is on 25/7/2018, on account of non-appearance of the petitioner, his evidence was closed. The matter was fixed for final argument on 26/7/2018, and on 27/7/2018, the order was passed. He submits that this all happened on account of the fact that the concerned judge was about to attain his age of superannuation by the end of the month. The Learned Council submits that several points have been raised in the show cause filed by the petitioner, including the point regarding additional liability which he has to incur in connection with his own parents. He has also submitted that for no fault on the part of the petitioner, the wife had started living separately. He submits that these aspects of the matter could be brought on record only if the petitioner could be witness. He has submitted that on account of closure of evidence on the very first day, and the manner in which the court has proceeded, the petitioner has suffered prejudice. However, during the course of argument, it is not in dispute. The marriage is not in dispute, and the children born out of the wedlock is also not in dispute. The Learned Council has submitted that the petitioner has been taking due care for the education of the children,
Including their, 1 minute, including their insurance and education. Insurance, my lord, we have also got with the reputed
including
company.
payment of insurance
of the children,
insurance for the children, including payment of premium for the insurance of the children. He has also submitted that on account of interim order passed by this court, an amount of rupees 2 lakhs has been paid to the wife towards arrear of maintenance, and rupees 15,000 being the 50% of the maintenance amount is being paid by virtue of insurance. Right? He submits that the petitioner has been deliberately paying the amount in terms of the order passed by this court. The learned counsel submits that one opportunity may be granted to the petitioner to adduce evidence so that fresh order be passed. He undertakes to cooperate with the proceedings before the law. That's it. That's it.
Right.
The learned counsel pleading on behalf of the opposite party by opposing the prayer has submitted that the marriage being not in dispute, the children born out of wedlock are also not in dispute. The income of the petitioner and the fact that he is holding a high post in the government service is also not in dispute. Therefore, the interim order does not offer any influence. He has also submitted that the learned court, by considering the materials on record, has considered the evidence of the wife and her cross-examination, and has also submitted that, and has considered that there was, and has considered the evidence of the wife passing the order. He has also submitted that in case this court is inclined to remand the matter, the proceeding may not start de novo. The evidences placed already on record and the submissions of the respective parties placed on record be taken into consideration. He has submitted that at best the evidence of the petitioner is to be taken. He has also submitted that the order of maintenance, the sum amount in connection with maintenance being awarded, may be the same would be by way of interim maintenance. Okay, sir?
Affidavit as per
The
name.
learned counsel has also submitted that in view of the judgment passed by the Honorable Supreme Court in the case of Rajit versus Neha, the parties be directed to place on record the affidavit in terms of the same judgment. He has also submitted that as per the same judgment, the maintenance has to be given from the table.
एक बात मेरे में छूट गया. The instruction is that the husband had spent about 8 lakhs of rupees on the education of the children and is spending 80,000 per month for the education.
ऐसा इंस्ट्रक्शन इतना आप केयर करने वाले होते तो मेंटेनेंस आपको देने में तकलीफ ही क्या? ये तो you should have been happy. इसे 30,000 रुपए में जान छूट रहा है. आप समझ रहे हैं? आपका मेंटेनेंस का क्वांटम कितना बढ़ सकता है? Do you have any idea about it? समझ रहे हैं? After hearing the learned counsel's appearing on behalf of the parties, this court finds that the petitioner was participating in the proceedings by filing his show cause, and the wife was also cross-examined, who was examined as a complainant witness. The marriage between the parties and the children born out of wedlock is not in dispute. It is further not in dispute that the children are minor and are school going / are still undertaking education. However, the fact remains that there was some confusion with regard to the next date in the matter, and the petitioner was under some impression that the next date was 25/8/2017, although the date was 25/7/2017. Consequently, ultimately did not appear on 25/7/2018, and on the very same day, his evidence was to commence, and the evidence of the petitioner was closed. In quick succession, the case was fixed for argument on 26/7/2018, and the order was passed on 27/7/2018, and the judge was retired at the end of the month. These facts which have been mentioned in the petition has not been disputed by the petitioner, by the opposite party by finding any counter. Considering the totality of facts and circumstances, this court finds that some prejudice has been caused to the petitioner on account of the fact that he has not been able to lead his evidence, and the proceedings were taken up on dates one after another. In view of the aforesaid facts and circumstances, this court is of the view that the petitioner should be granted an opportunity to lead his evidence, and in order to do so, the impugned order dated 27/7/2018 passed in judicial maintenance case number 87 of 2018 is hereby set aside, and the matter is remitted to the Court of Principal Judge Family Court Dhanbad for fresh consideration. It is further made clear that the materials which have already been the material which is already available before the court. It is further made clear that the materials which is already available before the court shall be taken into consideration, and the matter is being remanded only for the purposes of recording the evidence of the witnesses on behalf of the petitioner. It is this court also finds that this court also directs that in view of the judgment passed by the Honorable Supreme Court in the case of Razin versus Neha, the petitioners are directed to file their respective affidavits in terms of the same judgment before the court, so that the quantum of maintenance, if any, be fixed. The parties are directed to appear before the court on the date on convocation. Date बताइए सर.
But
6 January.
is it possible to get the copy of the order by that day?
आपको क्या लग रहा है? आपको ओपन कोर्ट में बोल रहे हैं, ओपन कोर्ट में ऑर्डर कर रहे हैं, आपका ऑर्डर जरूर सबमिट हो. बहुत नहीं होगा तो आज लास्ट वर्किंग डे है, 2 तारीख तक तो जरूर आपको.
हाँ हाँ, तो इसीलिए थोड़ा सा एक हफ्ता और 15th के आसपास आगे पीछे कुछ कर दीजिए. 15th के बाद कोई डेट.
15th of January 2024, along with their affidavit in terms of Razin versus Neha, it is also directed that the affidavit regarding Razin versus Neha should cover the period right from the date of filing of the maintenance case up to date. The learned court is directed to, considering the fact that the maintenance case is of the year 2018, the learned court is directed to pass a fresh order in accordance with law, taking into consideration the materials already on record and the further materials which may come on account of the evidence of the petitioner within a period of 2 months. 2 months? Yes.
2 months from today.
From the date of appearance.
No, from the date of appearance.
From the date of appearance.
Parties will, your lordship kindly say the parties will appear.
Certainly, आपको क्या लगता है?
नहीं शायद पिटिशनर ऑर्डर बुक हो गया है. पिटिशनर will
उनको
parties.
मेंटेनेंस चाहिए कि नहीं चाहिए? कि DFT कराना है? Since considering the entire facts and circumstances, the maintenance amount so fixed, the petitioner shall continue to pay the maintenance amount, current maintenance amount, so fixed by the court, right from the
By order dated.
right for the month from December 2024
Till disposal of it.
till the disposal of the case. It is further made clear that the amount so paid will be treated as interim maintenance subject to the final result.
By order dated 14/3/2019.
वो नहीं, interim maintenance जो आपने फिक्स हुआ है 30,000 रुपए पर मंथ,
अच्छा
वो आपको दिसंबर से पेमेंट शुरू कर देंगे।
नहीं ये तो
So far as the maintenance for the month of December is concerned, the same should be remitted to the opposite party.
ये हाई कोर्ट हम ये कहना चाहते हैं कि हाई कोर्ट का ये इंटरिम ऑर्डर 14/3/2019 का
वो नहीं कंटिन्यू करेंगे। जो इंटरिम ऑर्डर आप बाकी आप तो पेमेंट कर ही रहे हैं सबका,
हाँ, ठीक।
एडजस्ट कर लीजिए, क्या ही करना है इसमें। आप बच्चों का पूरा पढ़ाई करा रहे हैं ना,
हाँ
तो बस उसको एडजस्ट कर दीजिए, इसी में एडजस्ट कर दीजिए। आपके अनुसार तो जितना मेंटेनेंस फिक्स हुआ उससे कहीं ज्यादा आप खर्चा कर रहे हैं
ठीक है
बच्चों पर।
नहीं हम
तो आप ये वाला पेमेंट आप कर दीजिए और वो पेमेंट आप एडजस्ट कर दीजिए।
जनवरी से कर दिया जाए दिसंबर तो
जनवरी से नहीं, दिसंबर से।
अब क्या मालूम नहीं दिसंबर का पे हुआ है कि नहीं हुआ, तो फिर तो दिक्कत हो जाएगी ना। अगर if the husband has already paid so far with
So
December
if the 50% amount in terms of the interim order
dated
dated
14/3/2019
2019 has been paid by the petitioner to the opposite party for the month of December 2024, the same amount will be adjusted and the remaining amount will be paid for the month of December 2024 by 30%. And so far as January etc. is concerned, with the current maintenance up to 30,000 per month.
current maintenance fixed by the trial court.
Yes, of course. This division is already. The audit is very clear. Right. कल तक हम लोग अपलोड करते ज़्यादा अच्छा हो सकता है, इसको अपनी फाइल करने का मन करे।
Item 9, the LPC 5799 of 2018 along with item 10 and 11.
Paying for time and order on the ground of Mithil Singh is the arguing counsel in this case.
Counsel for the petitioner present, counsel for the
Respondent.
State. क्या ही करना है, फिर unnecessary order की क्यों dot?
जो इसमें एक इंस्ट्रक्शन है ना, one of the part of the state has prefer SLP before the best court, which was dismissed for default.
Against which order?
Against the order dated 9/2/2000. Against the order dated 4/11/2022 in first matter, item number 9.
4/11 बैच है क्या?
बैच केस हाँ ये बैच
SLP में क्या?
इसमें जो एक ESLP किए थे वो डिसमिस फॉर डिफॉल्ट हो गया है, उसकी वजह से हम कॉपी लाए हुए हैं। ये रेस्टोरेशन फाइल किए हैं कि नहीं किए हैं, वो जो इंस्ट्रक्शन
इन्होंने फाइल किया था ना?
हाँ इन्होंने फाइल किया था। ठीक है ठीक है
आप अपना केस पास करिए। ये सब इंटरलोक्यूटरी स्टेजेस का ऑर्डर है ना, ये सारे ऑर्डर्स तो इंटरलोक्यूटरी स्टेजेस का ऑर्डर होगा।
इंटरलोक्यूटरी स्टेज का ऑर्डर है
कोई बात
जो मिथले सिंह आर्ग्यूइंग काउंसिल ऑन द ऑफ स्टेट। इसमें जो हम भी टाइम ही चाह चुके हैं, हम स्टेट ज्वाइन कर लिए हैं।
पूरा बहस आपको क्या लगता है एसएलपी में रेस्टोरेशन हुआ है कि नहीं, इसलिए हम टाइम देंगे आपको?
नहीं इंस्ट्रक्शन क्यों ला जाता है मुझे?
कोई मतलब नहीं है। डीएमपी हो गया ना, डिसमिस हो गया।
हाँ डिसमिस
सब इंटरलोक्यूटरी स्टेजेस का ऑर्डर है, क्या ही फर्क पड़ता है इससे? इन्होंने किया होगा, इंक्वायरी वगैरह का ऑर्डर हुआ होगा, इसलिए किया।
My landed family was this to one accommodation may be given.
Counsel for the parties are present. They seek adjournment. कब चाहिए आपको? डेट बताइए।
20 जनवरी का आसपास लगा देंगे।
आपको बताइए।
After vacation in India.
With the consent of the counsel for the parties, close this case on 20th of January. Otherwise, the case is ready.
Yes, ma'am.
Otherwise, the case is ready or not ready?
हम मुझे एक सप्लीमेंट्री फाइल करेंगे, मॉडिफिकेशन फाइल करेंगे, हम फाइल कर देंगे बिफोर दैट, अदरवाइज केस इज रेडी।
कमीशन के 2018 वाले केस में आप क्या सप्लीमेंट्री फाइल करेंगे?
एक नया डॉक्यूमेंट हमको मिला है जिसमें ये कहते हैं कि ये क्या नाम है, ये लैंड जो है बिलोंग्स टू द गैर मजरूआ खास and by which taking the compensation order, not the गैर मजरूआ खास मतलब that was not been filed
अगर आप
earlier.
ऐसा फोटोकॉपी फाइल करेंगे ना बिना आरटीआई के then I'll institute a proceeding. ऐसा कोई चोरी का डॉक्यूमेंट मत लगा दीजिए.
चोरी का नहीं है.
फोटोकॉपी मत लगा दीजिएगा, ओरिजिनल आपसे मांगेंगे because you'll have to certify it to be true of it.
This document
In
which
the
is
midst of the proceedings you can't file a document like this. RTI में मिला है आपको? Certified copy आपके पास?
certified copy है.
कहाँ है original certified copy? Ready रखिएगा. ठीक है, जो भी कुछ करना है आप करिए, लेकिन कोई भी डॉक्यूमेंट in the midst of the proceedings अगर आप फाइल कर रहे हैं उसका सोर्स हमको एग्जैक्ट पता होना चाहिए. कई कौन सा तारीख को रखते हैं आप चूज करिए अपना डेट आपको जमा.
वो जो 20 तारीख को दिया जाए.
पोस्ट ऑन 20th of January. Next case है.
नहीं पास हो जजमेंट
Also, case item 201150 of 2019.
straight away I am placing para 26 इस केस का. इस केस में था जो कि सप्लाई करना था मशीनरी और मशीनरी सप्लाई करने की जगह पर वो पूरा नहीं कर पाए थे तो आउटस्टैंडिंग हो गया था. चेक उनका बाउंस किया, वो पेमेंट कर दिए. तो सुप्रीम कोर्ट ने पारा 26 में कहा है even though the complainant is unwilling to compound the case but considering the totality of the facts and circumstances of the present case which we have referred above, we are of the considered view that this proceeding must come to an end. नहीं हाँ 142 में है.
142 का पावर उनको नहीं है.
But in this case also my lord they
अगर आप यहाँ पे जो भी पेमेंट you want that should be remitted to them.
हाँ yes definitely.
Yes, we are ready to compromise.
And my lord 6 months.
Yes, boss, I have taken instruction. On instruction I am submitting.
So joint compromise
कर
इसको
joint
तब
compromise कर दीजिए.
तक हाँ इसको तब तक उसको बेल कर दीजिए. इसको कस्टडी में है मुझे बेल. ये 2 महीने 6 महीना का कन्विक्शन है. 2 महीना रह गया मुझे. आज 20 तारीख है 23 को उसको कस्टडी में लिया गया है. 2 महीने उस ऑर्डर को रिकॉल कर लीजिएगा तो ऑटोमेटिकली आ जाएगा वो पुराना ऑर्डर.
May I take your leave, boss? Case, may I take your leave, boss? One case is there in court number 3, boss.
ऐसे कैसे
He is there, boss. He is here, boss. He is here.
ऐसे नहीं होता है ना. उनसे कुछ सवाल पूछेगा भी आपका कोई कंसेंट लिखाएंगे कैसे लिखाएंगे आपका कोई कंसेंट. आप जाइए 3 तारीख
कस्टडी में है इसको.
क्या ही करें हम.
नहीं ही इज हियर माय लॉर्ड में डिक्टेट दी ऑर्डर. उतना देर में हो जाएगा उनका. चलेगा छुट्टी हो जाएगा आज के बाद.
बताइए आइए में क्या
आइए मन माय प्रेयर इज
show me your evidence in आइए that you have complied with.
यस मैम. my lord para 4 page 4. That pursuant to direction given by the Honorable Court, the petitioner has deposited the amount of compensation of ₹50,000 before the Honorable Court on 22/1/2020 by demand draft number 833277. Thereafter, my lord, the wide order dated 31/1/2020, the Honorable Court has been pleased to issue notice to opposite party number 2, since submission has been advanced by the counsel for the petitioner that order dated 16/2020 has been complied and petitioner has deposited ₹50,000 before the learned Registrar General of this court, and further ordered that petitioner was directed to be released on provisional bail. That it is humbly stated and submitted at provisional bail डेट नहीं था. केवल प्रोविजनली प्रोविजनल बिल है खाली हैज बीन ग्रांटेड.
कौन सा ऑर्डर
हम लगाए हैं हुजूर पैरा पेज 13 देखिए उसी order dated 31/1/2020 is directed to be released on provisional bail on furnishing bail bond of rupees 10,000. 31/1/20 का ऑनरेबल मिस्टर जस्टिस आनंद सिंह साहब का। ऑर्डर नंबर 6
डिमांड ड्राफ्ट आपका डिवैलिडेट हुआ?
अभी तो नहीं हुआ है, वो जमा हो गया था यहाँ पर, उसके बाद
डायरेक्शन
नहीं, वो जो रजिस्ट्रार जनरल साहब से मांगा गया था, जो कि वो प्रोवाइड नहीं करा पाए यहाँ पर हाईकोर्ट में, वही ऑर्डर हुजूर भी की थी, उसको कंसिडर करते हुए हुजूर का ऑर्डर है मेरे आईए का पेज 40 11/9/24 का। The learned counsel for the opposite party number 2 had submitted that in spite of order dated passed by this court on an amount of 50,000 by way of demand draft has not been deposited before the learned registrar general. He submits that provisional bail was granted to the petitioner by order as such and such, which has not been extended. In the order dated 31, the petitioner was directed to comply the earlier order dated 16/1/2020 to show his bona fide that he has deposited rupees 50,000 before the learned registrar general of this court. Since the order dated 16/1/2020 as well as the order dated 31/1/2020 with regard to deposit of rupees 50,000 before the learned registrar general has not been complied, the provisional bail granted to the petitioner is hereby
आपका तो कोई ड्राफ्ट जमा ही
नहीं, वो इसलिए आया था कि रजिस्ट्रार
हमारा ऑफिस नोट है कि आपने जमा
नहीं, ऑफिस नोट आया इसलिए हुजूर कि रजिस्ट्रार ऑनरेबल मिस्टर जस्टिस संजय प्रसाद साहब ने रजिस्ट्रार जनरल से मांगा था, रजिस्ट्रार जनरल के यहाँ नहीं जमा होकर के ये काउंटर में जमा हुआ था, फाइलिंग काउंटर में, उसी का हम एनेक्चर 1 लगाए हैं आईए में हम उसका एक्नॉलेजमेंट लगाए।
कहाँ है ओरिजिनल ड्राफ्ट?
हम उसका फोटोकॉपी सब दिए, वो तो ड्राफ्ट जमा हो गया,
ओरिजिनल कहाँ है? लेके आइए।
वो तो कोर्ट में जमा हो, हम नहीं ला
किसके
सकते।
पास? किससे हम मंगाए बताइए? आपका ओरिजिनल ड्राफ्ट
वहाँ बैंक वो लिक्विडेट भी हो गया है, वो भी आया, एसबीआई दिया है अभी रिसेंटली, वो इसका ये भी सर्टिफिकेट भी कि वो लिक्विडेट हो गया हाई कोर्ट में।
आप किसके नाम से ड्राफ्ट?
रजिस्ट्रार जनरल डायरेक्शन वाज
कैसे आ रहा है कि आरजी के पास कोई डिपॉजिट?
आरजी साहब के यहाँ डिपॉजिट उनके ऑफिस में नहीं हुआ था, काउंटर में हुआ था, जिसका एक्नॉलेजमेंट फाइलिंग काउंटर, वो पेज 12 देखा जाना मेरा आईए का। वो सर्टिफिकेट भी दिया है एसबीआई 24/11 का परहैप्स है, उसमें लिखा है कि वो लिक्विडेट भी हो गया है अमाउंट। एक्चुअली रजिस्ट्रार जनरल साहब के यहाँ ऑफिस में डिफिकल्टी है कि वो इशू क्या करेंगे, उनके पास तो रिसीट कुछ रहता नहीं, कंप्यूटर रहता नहीं है।
डिपॉजिट करना था आरजी ऑफिस में बाय ऑर्डर डेटेड 16/1/20।
हाँ, वो की वो काउंटर में जमा हुआ, फाइल हुआ। पेज 12 में आइएगा। वो वहाँ टेबल पे दीजिए ना सभी साहब। पहला है वो जो सर्टिफिकेट दिया है एसबीआई, उसके बाद वो लिक्विडेट हुआ है उसका सर्टिफिकेट है, ऊपर में लिखा हुआ है, और उसके बाद डीडी। डिमांड ड्राफ्ट नंबर होगा हुजूर 833727।
लेफ्ट से सेकंड या थर्ड कॉलम होगा, उसमें रजिस्ट्रार जनरल साहब का नाम होगा उसमें।
ये वाला जो डॉक्यूमेंट है ये तो है डिमांड ड्राफ्ट बनने लगा।
हाँ, वो और सबसे पहला पेज में है जो लिक्विडेट हो गया, हाईकोर्ट ने पैसा वो अपने पास कर लिया। डेथ सर्टिफिकेट,
तो मोहम्मद शकील अख्तर थाना
हाँ उन्हीं के नाम से, उन्हीं का बना, उन्हीं के अकाउंट से बना था वो।
ये तो एफिडेविट में भी नहीं लगा, क्यों नहीं लगा?
ये ला के दिया हुजूर अभी इसको रिसेंटली।
इससे हम नहीं ले सकते, हमारा ऑफिस तो डॉक्यूमेंट जमा नहीं हुआ है, तो हमको तो पूरा इंक्वायरी करना पड़ेगा।
नहीं, हम तो लगा दिया है हुजूर, एनेक्चर 1 लगा हुआ है। एनेक्चर 1 फॉर मोमेंट देखा
नहीं कर सकते आप इस तरह से डॉक्यूमेंट।
नहीं, ये एनेक्चर 1 लगा हुआ है।
इलेक्शन वाला ये सो सर्टिफिकेट है ये सब।
वो सर्टिफिकेट हम नेक्स्ट डे पे जो जिस दिन फिक्स करेंगे हम लगा देंगे उस दिन, लेकिन ये लगा हुआ है एनेक्चर 1। बाईस 1/20 को मोहम्मद अतीक के केस में फाइल हुआ।
ID number
1, 2, 3, 5
of 2024 has been filed for recall of
order dated
order dated
11/9/2024
11/9/2025
4 में
11/9/2024 whereby the provisional bail granted to the petition has been cancelled. They have submitted that the amount was deposited before this court
in the filing counter.
in the filing counter.
Yes, ma'am.
And in support of that, he has annexed Section 1. The learned counsel submits that the demand draft was not directly deposited in the office of the learned registrar general, and therefore this conclusion is true. He has submitted that the petition has been taken into custody after cancellation of bail.
On 23/10/2024.
On 23/10,
2024.
2024. The learned counsel for the petitioner and the opposite party number 2 have also submitted that the matter can be, there is a likelihood of filing a joint compromise petition as the entire compensation amount of ₹50,000 has been deposited before this court, and on instruction the petitioner has submitted that he has no objection if the amount is given to the opposite party number 2 as a part of compromise.
And as directed by the learned trial
Directions
court. नहीं, learned trial court in
जहाँ पे
compensation.
compromise का कोई डायरेक्शन कोर्ट से नहीं।
नहीं, court से।
Considering the aforesaid submission, the petitioner is directed to be released on provisional bail.
इसको रिकॉल कर लेते
फ्रेश
हैं,
करना पड़ेगा ना, बेल बॉन्ड आपका कैंसिल हो चुका है।
उसको रिस्टोर कर देती तो
कैसे करेंगे? Is directed to be released on provisional bail. On furnishing bail bond of ₹10,000 with two sureties of a like amount each to the satisfaction of Chief Judicial Magistrate Lohardaga in connection with complaint case number 476 of 2017, in bracket TR number 46 of 2019, 31/1/2020 के order में ये details दिया है. That is order be immediately formulated to expose this case on, बताइए.
लास्ट वीक में लगा दिया जरूर इसको, तब तक हम कहाँ सप्लीमेंट्री ये हम लोग जॉइंट कॉम्प्रोमाइज कर लेंगे।
Just a moment. On 24th of January
हाँ,
2025, in the supplementary list.
मतलब may I take back?
ये जरूर रखूँ।
मतलब may I take back my दिमाग ताकि उसको लगा देंगे।
Notified case. Item 1 WPC 3423 of 2015.
समय मिर्ची